On behalf of the Wisconsin Institute for Public Policy and Service and UW Marathon County Lecture in Fine Arts Series, we welcome you tonight to our event entitled Contraception, Religious Liberty, and the Affordable Care Act. It is my pleasure to introduce tonight's moderator, Mark Brown. Dr. Mark Brown has been a professor of philosophy at UWMC for 25 years. This semester, he is teaching biomedical ethics and expects his students to sit up straight and pay attention tonight. Professor Brown is the author of 2 papers that bear upon tonight's topic: The Potential of the Human Embryo, published in 2007 by the Journal of Medicine and Philosophy, and Moral Complicity in Induced Pluripotent Stem Cell Research, published in the Kennedy Institute of Ethics Journal in 2009. He is also a WIPPS Senior Fellow. We're grateful to have you here tonight, Mark. Thank you for all your work in organizing this event.
Thank you, Eric, and good evening. The contraceptive mandate is a controversial provision of the 2010 Patient Protection and Affordable Care Act, the healthcare law also known as Obamacare. We are fortunate tonight to have as our guest Matthew Bowman, one of the most able critics of the law, and Francis Kissling, one of its most eloquent defenders. Matthew S. Bowman is legal counsel, senior legal counsel for the Alliance Defending Freedom, a nonprofit organization that represents clients around the country who assert religious liberty rights. Mr. Bowman was lead counsel in Newland v. Sebelius, the first successful challenge to the contraceptive mandate. On July 27th, the District Court of Colorado granted a preliminary injunction blocking implementation of the contraceptive mandate to Hercules Industry, a home heating and air conditioning company owned by the Newland family. Matt is a very busy man. The Newland case almost certainly will be appealed by the Department of Justice. It is likely to go through the federal appeals court circuit and may well end up on the docket of the Supreme Court. Thank you, Matthew Bowman, for taking the time to come to Wausau to talk to us about this issue. Francis Kissling stands in the proud tradition of liberal Catholicism, alongside Dorothea Dix, John Courtney Murray, and Jacques Maritain. Ms. Kissling is the founder and for 25 years was the president of the nonprofit organization Catholics for Free Choice. She is the author of hundreds of articles on reproductive rights. And the book, Rosie, the investigation of a wrongful death, about a woman who died from a botched abortion. Francis Kissling has been at the forefront of recent efforts to bring together pro-life advocates and pro-choice advocates in civil, respectful, and reasoned dialogue. Thank you, Francis Kissling, for bringing this model of civil discourse to the Wisconsin Institute for Public Policy and Service. Matthew Bowman will speak first, make the case against the Affordable Care Act contraceptive mandate. Francis Kissling will then speak, defending the Affordable Care Act as a reasonable balance between religious liberty and public health. This is a debate on a quite specific issue in public policy, but it also is a debate that touches upon profound questions in moral philosophy. Let me briefly state the issue and say something about the philosophical issues at stake. Beginning in August 2012, the Affordable Care Act requires that new health insurance plans must offer a uniform package of essential health services. This could be federally subsidized individual health insurance, or it could be through group health insurance provided by employers with federally subsidized pre-tax health insurance fringe benefits. Noncompliance would result in a penalty, effectively reducing the federal subsidy. Among the mandated essential services are a variety of preventive care benefits, such as vaccination, cancer screening, and federal FDA, federal drug-approved contraceptive medications and devices, emergency contraception, and the IUD, ELA, included among those. Abortion, understood narrowly as pregnancy termination, is specifically excluded by the health care law and by the Hyde Amendment and other federal statutes. Now, of course, the law could change. But as things now stand, Affordable Care Act does not mandate that employers or the public pay for therapeutic abortions as understood by the Institute of Medicine. I'm sure we'll talk about exactly what that definition comes to as the evening goes on. So one thing you might be thinking is, why should contraception be considered health care? I mean, after all, pregnancy is not a disease. But recall that the pill and other contraceptives are considered essential health benefits under the heading of preventive health care. And pregnancy is a condition that needs to be medically managed and may have a substantial impact upon the health of a woman in the short term and over the course of her lifetime. There's also evidence that planning and spacing of pregnancy results in health benefits for newborns, notably birth weight and prematurity. And some contraceptives, notably the birth control pill, provide other health benefits, protecting against certain kinds of cancer and endometriosis. So it's not unreasonable to think of contraception as health care. That's the way most American women seem to think about it. 90% by some estimates go to their doctors for contraception at some point in their lives. Some employers are exempt from the contraceptive mandate, from the regulation. The Affordable Care Act permits health care plans to be grandfathered into the regulatory regime in order to permit an orderly transition. And religious institutions such as churches and synagogues that employ and serve people who can be expected to share the values of the religious institution also have been granted an exemption, a conscientious objection exemption. But what about religiously affiliated organizations like hospitals and universities and schools? Catholic institutions of this kind, for example, employ over 1 million Americans who cannot be assumed to agree with the teachings of the church on contraception. Other companies, notably Hercules Industries, may, as indicated in the legal brief, may seek to run their business in a manner that reflects their sincerely held religious beliefs. And to offer a health care plan that covers contraception would be contrary to the company policy that encourages employees to, quote, follow appropriate religious and ethical moral standards. This is a genuine moral dilemma, I think. Employers quite reasonably object to a regulatory regime that puts them in the position of enabling or endorsing practices that they find morally wrong. And on the other hand, employees quite reasonably object to a regulatory regime that embeds religious doctrine and moral conviction in the terms of employment. Here, I think moral philosophy may be of some help. Conscientious objection to the contraceptive mandate is motivated in large part, not entirely, but in large part, by the belief that certain contraceptives, notably emergency contraception, Plan B, Ella, and intrauterine devices, and in some instances, the birth control pill, may prevent pregnancy by preventing the implantation of a human embryo in the uterus. Now, if one believes that human life begins at conception, then it is not unreasonable to believe that these contraceptives are morally equivalent to abortion. And it is not unreasonable to believe that something momentous happens at fertilization, at conception. But it also is not unreasonable to believe that human life begins over a more extended time frame and is not complete until after these contraceptives have had their effect. In the last 30 years, the process was removed from the darkness and the privacy of the womb and studied under microscopes and in vitro fertilization clinics all over the world. We now know that fertilization itself is a process that takes a full day to complete, 20, 24, 26 hours. That fertilization may not commence until 1 or 2 days after intercourse. And the first week of embryological development seems to be about building a placenta more than the development of a human person. Now these discoveries do not necessarily imply that life does not begin with conception. They are consistent with the view that life does begin at conception, at the fertilization event, which occurs over the period of a day or 2 or 3 days. But it does suggest that it's not unreasonable to think that human life begins, the human person commences to exist later. That was the view of the Institute of Medicine when it recommended coverage of contraception under the Affordable Care Act. That's one reason why the Institute of Medicine defines abortion and abortifacient remedies as termination of a pregnancy, which is understood as implantation of an embryo in the uterine wall, roughly at 10 days to 2 weeks post conception. It seems to also be the view of millions of people who have used in vitro fertilization technology to have babies, and it's implicit in the actions and beliefs of millions of women who use these contraceptives. So all I'm suggesting here is that there is room for reasonable disagreement on this issue. And I'm not suggesting that resolves the moral dilemma of conscientious objection. That's exactly the topic that we are here to address. But it does shift attention to a fundamental, a deeper moral dilemma, the moral status of the human embryo. In philosophy, we call that progress. So let us now welcome Matthew Bowman and Francis Kissling, and please.
Thank you. Let me adjust some things here. Thank you all for coming out tonight. This is a great crowd, great turnout. Parking lot is full. I'm sure that everyone at the Institute is glad to see that. Thank you, Professor Brown, for organizing this event. Thank you, Professor Giordano. Everyone at the Wisconsin Institute for Public Policy and Service for organizing this. Thank you for the steering committee, to the Lecture in Fine Arts series sponsors that helped make this event happen. And thank you to Ms. Kissling for engaging in this conversation. 50 years ago in 1962, William E. Newland of Denver, Colorado, and 5 employees started Hercules Industries, a heating, ventilation, and air conditioning business. His children became involved in the business, and eventually his grandchildren. And this Catholic family now has a business that employs nearly 300 people. The family's Catholic faith guides them to treat their employees with the utmost dignity. That includes paying them very generous wages at even at the lowest rate, at several times the poverty level. It includes a self-insured health plan that ranks in the 11th percentile in terms of employee benefits. And that plan includes generous women's health benefits. It includes generous benefits for pregnancy. It includes wellness benefits for women and risk reduction. But last month in 2012, the federal government threatened massive fines and lawsuits against this family-run business that would have shut it down and left its employees with no job and no health insurance. Why? Simply because the Newland family wanted to run its business consistent with its belief that they opposed providing in the health plan abortifacient drugs and devices and contraceptives and sterilization. Now, at their request, I and my colleagues at Alliance Defending Freedom filed a lawsuit against this unprecedented mandate that came down from the Affordable Care Act, also known as Obamacare. And in July, the first and only federal judge to so far rule on the issue of whether this mandate violates religious freedom granted an injunction against that mandate while the case is pending. That injunction protects the Newland family from having to have paid for these drugs and devices that they consider immoral starting November 1st. Judge John Kane, who issued the decision, who was appointed to the federal bench in 1977, declared that the government, quote, completely undermined, unquote, its own supposed interest that it claimed it had to coerce this family. And he also wrote that the alleged public need for this coercion, quote, pales in comparison, unquote, to the constitutional and statutory religious freedom claims that the government was threatening to trample upon. But this isn't just an issue for Catholics such as the Newlands. This applies to plans of all kinds, and Professor Brown pointed out that the mandate applies to new health plans. It doesn't just apply to plans, respectfully, that are federally subsidized. He said that all employer-provided health plans get a tax benefit, but the Supreme Court itself has ruled that even a tax credit isn't the federal government paying for it. It's the federal government just not taking that money from you. Leaving that issue aside, though, at Alliance Defending Freedom, we don't just represent Catholics on this issue. We, in fact, represent 4 evangelical Protestant colleges that don't oppose contraception and actually provide contraception in their health plan. But as Professor Brown mentioned, they object to providing coverage for items that they view as causing early abortions, destruction of the embryo after its fertilization. So the issue at stake here is not really a debate about birth control itself, but it's a debate about religious freedom. And it's important to distinguish your views on birth control, your views on whether some of these drugs are abortifacient, or your views on sterilization from the issue of religious freedom implicated in this mandate. And it's important to listen to the description that Professor Brown, I think, gave well of why some people hold the view that human life does begin at fertilization and demands our respect and requires us, in some ways, morally not to participate in its destruction. And that, as many of my clients contend, that God has a plan for sexuality that does not include them promoting devices that would directly interfere with that plan. But the question of this federal government mandate is not what you think about birth control. The issue is this: do we want to live in a society that takes diversity and pluralism seriously? Do we want to live in a society that makes room for freedom of conscience against government mandates? So whether it's birth control or not is not the issue. The question is, should our country impose mandates with no allowance for conscience? So, for example, during wartime, should our country make room for conscientious objectors, not only to military service, but should it force those objectives, for example, to work in tank factories or missile factories? Suppose you live in a state that has capital punishment. Should doctors be able to object to having to assist in lethal injections if it violates their conscience? Or should the government be able to mandate those? Suppose you ran a manufacturing or you worked in a technology business. What if the government came along and forced you to contract with the Department of Defense in order to create implements or mechanisms of the war on terror, or of assassination, or of covert surveillance? Suppose you were training for the field of psychology. Should a state licensing board be able to force you to participate in what's known as reparative therapy that might convert people who have homosexual tendencies into people who have heterosexual tendencies? This therapy does exist. Suppose a state were to say this is the way to go, and you can't consciously object from that. Suppose you were in a company that made food or cosmetics. Should the government be able to force you not only to test your products for safety, but to test them in ways that torture monkeys or kittens? If you were a manufacturer of environmentally responsible automobiles, should the government, in an attempt to promote domestic jobs and consumption of U.S. mined fossil fuel, be able to force you to sell gas-guzzling cars and impose a maximum 10 miles per gallon ratio? The question is not what you think about birth control or abortifacients in this mandate. The question is, should our society freely accommodate religious conscience against government coercion? In fact, historically, America has freely accommodated religious conscience. The most obvious place of this accommodation is the First Amendment itself, that the government shall not restrict the free exercise of religion. Now, some people will explain to you that in 1990, the Supreme Court issued a decision that scaled back on that protection. The impact of that decision, I think, is overblown for reasons we could get into if you're curious. But I think it's important to note that the Supreme Court still strikes down laws and lower courts as violating the First Amendment restriction on free exercise of religion. And more importantly, that very shortly after that decision, in the early 1990s, President Clinton signed a bill passed by a broad bipartisan coalition in Congress that imposed that strictest level of scrutiny, once again, to federal mandates such as the one that we're talking about tonight through Obamacare. This level of strict scrutiny that's called in the courts is what the Supreme Court says is the most demanding test of constitutional law. This is the level of respect that you don't get a higher level of scrutiny in federal court than the one that President Clinton's law gives to religious freedom. Nadine Strawson, the national president of the ACLU, testified in support of this law, and she said that it was intended to safeguard, quote, such familiar practices as permitting religiously sponsored hospitals to decline to provide abortion or contraception services. And the Supreme Court applied this law in a case just a few years ago where the court unanimously upheld religious freedom against even a regulation of the most dangerous of illegal drugs. But that's not all. Federal health statutes also provide very broad protections, not only of religious convictions, but of moral convictions. Shortly after Roe v. Wade legalized abortion in 1973, Senator Ted Kennedy went to the floor of the Senate and, with almost a unanimous Congress, passed a law that not only protects people from assistance in abortion, but also has a section of the law that protects people from violating their conscience to assist in, quote, any lawful health service. And this law covers individuals and institutions in various circumstances. The Obama administration, in a document it issued a couple years ago, said that this specific law, with regard to this specific law, that healthcare entities must continue to comply with it. Senator Daniel Patrick Moynihan, a Democrat, proposed a religious and moral conscientious objection bill that would have applied to President Clinton's initial proposal for health insurance reform, sometimes derogatorily referred to as Hillary Care, but it would have had a universal religious and moral exception to coverage. President Clinton then, before he left office, signed several statutes that provided religious and moral conviction protections for entities that objected to covering contraception in insurance, including in the District of Columbia, in Medicaid managed care plans, in Medicare choice plans, etc. The list goes on. This is a robust tradition in America of protecting religious freedom at the federal level. including in the policy relating to contraception. So I find it very troubling that in this debate, that obviously touches on very serious emotional and personal issues, nevertheless, that in this debate, when a bill was proposed in the House and Senate to simply add a religious and moral convictions provision that would have been consistent with all of these laws that President Clinton signed and that Senator Moynihan and Senator Kennedy were in favor of, that this bill was claimed in public to, quote, treat women like property and to send us back to the Dark Ages. Well, it's only the Dark Ages if they mean the Clinton years, and I don't think that's what they were referring to. It is not totalitarianism to live in a country that protects religious freedom. That's actually a very ironic claim. Now, the government, in this case, has actually offered very sparse evidence to justify violating this very massive tradition of religious freedom. The Institute of Medicine, which Professor Brown referenced, is not a government body. It's a private body of experts that the government relied on. So not only was this mandate really implemented by government bureaucrats at HHS, but it was really implemented by people who aren't even the government itself. But they relied on supposed evidence on the need to mandate this coverage in health insurance. But the supposed evidence is not only hypothetical, but self-referential and circular. The evidence from the Institute of Medicine report is based primarily on the theory that whether or not a pregnancy is intended, that fact alone, is it intended or not, has these physical health effects, and that contraception will make pregnancies not intended, it'll prevent these physical health effects, and that if we mandate it on employers, that'll trickle down, the trickle-down theory to actually all these health benefits. But the Institute of Medicine itself admitted that the, quote, research is limited in this area. It had to refer back primarily to its own study from 1995, in which research was even more limited, and in which that study itself admitted that whether the effect of contraception, whether these bad effects that contraception is supposed to prevent, whether those are caused by or merely associated with unwanted pregnancy, is questionable. And the study admit that it even had trouble defining what unintended pregnancy was. So again, the theory behind this mandate is, oh, well, if there's unintended pregnancy, then this will lead, this has a sort of, it's sort of associated in certain populations with things like low birth weight, which then has other health effects. And to connect the dots from that sort of hypothetical proposal all the way to, and now we need to mandate everyone to violate their religious freedom, it's not even a close call from a test that's going to impose the most demanding standard known to law that respects religious freedom. What the Institute of Medicine did say, however, is that the same reasons it decided for supporting the mandate here of birth control, including what some people consider abortifacients, those same reasons, according to the Institute of Medicine, would have justified an imposition that health plans cover abortion writ large. They said that despite the potential health and well-being benefits to some women, abortion services were considered to be outside of the project's scope. So they felt like they didn't have the legal ability to impose that mandate, but the same reasons they were giving to claim that contraception was so preventive it had to be mandated on everyone, they believed applied to abortion too. And in Denver, the Obama administration's lawyers, in opposing the injunction that we eventually secured, argued that the legal clause within the Affordable Care Act, that it's supposed to protect health plans from a federal mandate of abortion coverage, that legal clause really only applies to a very small set of health plans, not including the Newland family's own health plan. So a bunch of pro-life Democrats who eventually were the margin that let Obamacare pass in 2010, based on this provision, in part, under the Affordable Care Act, the Obama administration now takes the position that this provision doesn't even stop them from mandating abortion itself in many health plans, if not most. So the question I want to raise to you is this: how did this tradition of robust protection for religious freedom not only become vilified and undermined, but how did religious freedom itself come to be labeled coercion? Now, this is where I think that we get to some of the arguments in favor of the mandate. The arguments that I see in favor of this mandate are the idea that it's actually freedom and religious freedom and conscience freedom for us to force you over your objection to pay for and provide other people's devices to enable their sexual choices. In other words, if an objector doesn't facilitate the sexual choices of other people, it's the objector who's imposing his views, not the other people who are demanding that he pay for it. Now, to describe it this way, I think, illustrates the irony of the claim. Freedom and rights, of which in the last 50 years the Supreme Court have categorized abortion and contraception, have now become not just the ability to do things, but a requirement that everybody else pay for it and help me do it. And the way they've done that is primarily through the term access. What you will hear, I think, in many debates is no longer a discussion about the right to abortion, but to access to abortion, or the right to contraception, but to access to contraception. And this is a semantic shift that has enabled people to take what at the time of Roe versus Wade was, don't worry, we're just making it legal, to everyone else has to help even if they object. Now, this was not always true. Roe versus Wade itself, widely criticized as inventing a right to abortion that didn't exist in the Constitution, even on the left, Roe versus Wade itself was very insistent that, for example, the American Medical Association's resolution in favor of conscience protection wasn't consistent with it. In other words, we're requiring that states allow abortion, but it's entirely appropriate that no one have to participate if they don't want to. The Supreme Court's companion case, Doe versus Bolton, described a Georgia statute in which a hospital or an institution was free not to have involvement in abortion, and it said these provisions are, quote, appropriate protection. So what at the time was a movement in favor of choice, both a public movement and a legal movement, has shifted to become a movement of coercion of others to make these choices happen, to help other people make these choices. And the coercion agenda, the shift from choice to access, which is, I would argue, code for coercion, that agenda is really, not only is it ironically self-contradictory, but it's entirely one-sided for this reason. Even if the notion that people ought to be able to access what they want were the notion that we would operate on, it wouldn't lead to the destruction of conscience rights, it would lead to the protection of them. Because there are many patients, there are many Americans who want to be able to access health care and health provision and health options that are consistent with their beliefs and that don't necessarily share the beliefs of people who want to impose abortion. There are people who want health plans that don't provide contraception because they don't want to pay into it. There are women who want doctors who don't do abortions so that they can have their baby delivered by a doctor who unconditionally cares for the life of the unborn child. And to say, we're going to require providers, we're going to provide health insurance to always participate in abortion and contraception is to destroy the population of people who don't do it because they take a different worldview of medicine, a Hippocratic worldview, and is to deny the access to those people for tens of millions of Americans, the people who share traditional views about medicine and life and sexuality, who want to be able to access health care, health insurance, and who won't be able to find a health plan under Obamacare that doesn't provide abortifacient drugs, where they're not going to be paying for those drugs and devices because they won't be even legal to have one of those health plans. And so, again, the coercion agenda is not only self-contradictory, it loads the dice in favor of a set of things that come from the sexual liberation movement that only one side of the debate favors. For example, the Obamacare mandate we're talking about tonight doesn't just force employers to provide these things. Okay, it forces the dependents of the person covered to have free contraception and sterilization. So, what does that mean? If you're an employee somewhere and you have kids, Obamacare forces you to have a plan, and if you're paying into that plan, to pay into a plan that gives your kids free contraception and sterilization, even if you don't want to help your kids get free contraception and sterilization. Obamacare makes them have access to it through this health plan. So I represent another business run by Catholics in Western Pennsylvania. It's a small business, so a good portion of the employees are themselves the owners and are Catholics. They don't want to pay for free contraception and sterilization to their kids from age 12 to 26. But Obamacare makes them do it because there are no other options. It's not legal to have another plan. The beneficiaries of this shift from rights to access to coercion are really special interest groups that in many cases actually sell and promote the kind of services that they're loading the dice of the argument to provide. It would be like McDonald's saying that there's a universal right to access hamburgers, but then to implement that in a law that lobbies to coerce all restaurants to sell actually Big Macs because there's a universal right to hamburgers. So when people say that coercion somehow serves freedom of conscience of employees, they're not only being ironic by defending coercion in the name of choice, they're using government penalties to suppress one side of the debate. Ultimately, the question is also one that Professor Brown raised, which is this. When the government decides to treat pregnancy as a disease, it mandates a different worldview towards pregnancy. Pregnancy, under the theory of the government in this case, is that the reason why it has to be contraception has to be mandated coverage is because pregnancy is expensive, pregnancy is unhealthy, and pregnancy ought to be entirely autonomous. So what do we do in a country where the government controls the health provision system and the rules surrounding it? And pregnancy is now required to be treated as an expensive, unhealthy lifestyle choice. Well, we know what the health system does with expensive, unhealthy lifestyle choices. It disincentivizes those choices. Pregnancy is the new smoking under this rule. And when the government is controlled, those disincentives will eventually themselves involve positive coercion. It seems to me, if that's the premise that we're adopting about what everyone has to treat pregnancy as. So, in Ms. Kissling's article in the Wausau newspaper the other day, she made a statement, while the government has no place in the bedroom, it can adopt policies that either encourage or discourage responsible pregnancy and childbearing. Now, I don't know if she was making a sort of factual observation about what the government actually is able to do, or whether she was saying that it ought to do. But the notion that American government might be able, in some appropriate way, to quote, discourage pregnancy, should be alarming to people committed to freedom. In this country, the tradition of religious freedom is incompatible with this Obamacare mandate of contraception and abortifacient coverage. The only court to rule on it pointed out that the government is allowing a variety of exemptions to this plan. In fact, 191 million people, almost 2/3 of the country, are not subject to this mandate, but people who have religious objections are. And what ultimately ends up being the case is that mandates such as this are really guises that are used to only target the people who dissent from the orthodoxy of the sexual liberation movement that promotes these things. So 191 million people under Obamacare don't have to follow this mandate. Why? Because the bureaucrats said so. They think it has economic or other efficiencies involved with it. But at the same time, the government claims that interest is so fundamental, so paramount, that the republic will fall apart if we don't impose it on people who religiously object. This is a policy to simply get the people who dissent from this view about contraception and abortion into line, to get them participating in it, to get them complicit in it, because some people simply don't tolerate the diversity of a society that allows people to live and fully participate in society when they're holding these views. And that's why you often hear the comparison between this mandate made with civil rights laws and racial laws. The comparison really isn't apt. But the fact that the comparison is made is illustrative of the fact that if you have a traditional view of medical ethics or of life or of sexuality, you're in the category of bigot. And we're going to turn the wheels of society against you to treat you like a bigot. That's a dangerous precedent. America's strength has been in its diversity and pluralism, and a central part of that has been the freedom to exercise religious beliefs in these societal activities. The kind of coercion that's being implemented already under Obamacare, from which many more mandates will follow, should be stopped before additional mandates come forth against religious freedom. Thank you.
Let me also express my appreciation to everyone at the university, to Mark Brown most especially for his assistance to both Matthew and myself in planning this and setting up a nice structure for this, and to all of you for attending. Very often, the subjects we're talking about tonight, both procreation and religion and religious liberty, are the kind of issues that arouse enormous passion. Matthew referenced the fact that they were emotional issues. And it's very hard to find forums in which people who believe strongly one way or another, or 5 ways and another, because these are not simply binaries, can really talk to each other, hear each other, and try to understand each other. My goal in presenting tonight is not to convince you of anything. Most of you came here already convinced of something on this subject. Perhaps a few of you are leaning one way or leaning another way and not quite sure how this comes out. My goal in my presentation is to give you a sense of some of the questions, some of the dilemmas associated with the topic. I think that, and Matthew, I appreciated your presentation very much. I think that generally, and I don't think it fell into what I'm going to say, generally lawyers have a certain approach to public policy issues. They have to go into court, and they have to win or they have to lose. I'm not here to win or lose. I'm not a lawyer. My interest is in the ethical side of these questions, and my interest is the singular question, in a sense, of what is the right thing to do in a given dilemma. And I want to start to say by, I think we have a dilemma here. A number of goods, this is how I see it, a number of goods come in conflict. I want to say that when I say this is how I see it, I think of a quote from the French writer Anais Nin, in which she said, "We don't see the world as it is, we see the world as we are. We are all deeply influenced in evaluating facts, research, reports, policies, and opinions, and our environment based on who we are." The idea that we objectively see the universe or the world is not quite right. Okay. So, I want to talk about 2 things concretely. There are 2 goods that come into conflict, in my opinion. We hear a lot about one of those goods, religious liberty or religious freedom, the right to follow your conscience. And for most of us, that seems a very clear concept, okay, and a very high value. And I'm not going to use the words of the law or the words of the Constitution around strict construction, fundamental rights, etc., but more the words of values. Freedom is a high value for most of us. And freedom exists on many levels. The freedom to follow our conscience and practice our faith, to act in accord with it, is a great freedom for us. The freedom to procreate, to bring new life into the world, under good circumstances, when we believe it is correct and responsible to bring that life into the world, is also a value. And we tend to denigrate that value. And we tend not to understand, it seems to me, what we mean and what it means for a woman or a couple to make the decision to have a child. We have to some extent become so obsessed with not having children or with abortion that we've lost this sense of the enormous good and responsibility associated with procreating. And it's a right. It's a right. Some would say it's a sacred right. But it's a right that also is accompanied by responsibilities. It involves a set of acts, behaviors, and relationships that are very private and very intimate. Those acts, behaviors, and relationships have public consequences. Procreation is both a private act and a public reality. We are not isolated individuals. The decision that Matthew referred to, Roe v. Wade, says this. It says a woman should not be isolated in her pregnancy. It's also the idea that the government does have, and it is a double-edged sword, the right to encourage childbearing and the right to discourage childbearing. And we don't have enough time in this lecture to talk about whether that's a good thing or a bad thing, or when it's a good thing and when it's a bad thing. Some people think it's a good idea when the state wants to encourage childbearing, and a bad idea when the state wants to discourage childbearing. We don't necessarily have consistent views on these things. They are colored. The basic fundamentals are colored by how we view the act of procreating. Those who are more pro-natalist tend to view the government's encouragement of childbearing as a good thing, and its discouragement of it as a bad thing. And those who take a more liberal view, who perhaps are more in favor of the ability to end a pregnancy, or who have concerns about population and environment and poverty, who think, hey, maybe we shouldn't be encouraging so many births, see it differently. So we lose sight of the overall principle in terms of where we come from. Now, in relation to this question of pregnancy, and in relation to the question of a couple's and a woman's ability to exercise that right in a responsible way, we need to understand that we're not talking, when we're talking about this question of a mandate for insurance, that employers must provide insurance coverage for contraception, we're not talking about sexual freedom. We're not talking about, the kind of Rush Limbaugh approach to you want people to pay for your sexuality. It's not about paying for sexuality. It's about paying and providing the possibility for people to become parents when it is appropriate for them to become parents in the context of their moral values. And while among us there are different views about what is the right way not to become a parent when you are not able to care for children, abstinence, use of contraception, even access to abortion. We have different views about that. I think we have some commonality that says to us, having a child, deciding to become pregnant, And deciding to bring a new life into the world is one of the most important decisions any one of us can make in our lives. Important at many, many levels. Pregnancy, it's true. You could say pregnancy is not a disease. I want to cover the pregnancy side of this. You could say pregnancy is not a disease. But pregnancy is a condition that always carries with it the risk of death. We think, most people kind of view, we live in the United States of America, we have the greatest maternity care in the world, women don't die in delivering children, but there's probably a fair number of people in this audience, young and old, who are aware of pregnancies undertaken in the best of conditions, in absolutely excellent health circumstances, that have ended tragically for women and for their children. Amnesty International issued a report about 5 years ago on the maternal mortality rate in the United States, and said that it was a disgrace, the number of women in different communities who are still dying when they become pregnant and carry those pregnancies to term, and suffering. We have enormous difficulties in our society around the increasing pregnancy rates and the increasing childbearing rates among those among us who do not have the resources to care for their children. These are very important public policy issues. Our government has made a decision that it considers the ability of women to prevent pregnancy when they are not ready, when they choose to, and are not ready to bring children into the world, and not capable of caring for them. We consider that a great public health issue, very important public health issue. And since we do believe in procreative freedom, as we believe in religious freedom, we have decided that we want to make it more possible to deal with the public health dimensions and to deal with the procreative rights of women. And so that is, in my opinion, that's the way I see the decision that the government reached, that Health and Human Services reached in deciding whether it would consider contraceptive coverage among the core basic primary health services that would be made available without additional cost to employees, because in many cases employees do contribute often to their health insurance, and it is considered part of their benefit package, so in a sense it's part of their salaries. So they are actually paying for their contraceptive coverage. Okay. But we decided that this was important enough that we would make it available in the same way we make other primary health care services available. And that it is primary health care because the formation of families and the bringing of children into the world is one of the most primary and essential functions of individuals and of the society. So that's how I see the neglected side of the tension between the desire to respect the religious beliefs and to grant religious freedom, and the desire to respect procreative freedom, the rights of children, the rights of families, and the public health consequences when couples and women are unable to enact the decisions they make about having children. I just, hooray for women, okay? And hooray for the formation of families responsibly. So what did the government actually decide? I think that Matthew raises a number of very important points that I think about a lot, which go far beyond, but are related to this specific decision. And there are a great many dilemmas associated with how we can negotiate this question of religious freedom. But he raises big questions for the future about where and how will religious freedom be honored? Let's say Christian science employers decided that they don't want to provide health care coverage at all. It's against their religion to see doctors, against their religion to have surgery. So, they could ask for a religious exemption from providing any health care coverage at all, or only health care coverage for Christian Science doctors or Christian Science healers. Or let's say Jehovah's Witnesses Jehovah's Witness employer decided, I don't want any coverage for blood transfusions in any insurance policy I give to my employees. It's a religious belief that you shouldn't have blood transfusions. We've dealt with this in the context of children, but this is in the context of adults. I'm not covering these blood transfusions, period. No way. Okay. I think, again, Matthew raised some very good points about one side of the equation of what happens, but all of those things, if you're going to have a real discussion, you have to flesh out all of those things, pluses and minuses on both sides and in both directions. So I wanted to raise some of those. But really, what is it that the government has said here, and what is it that the government has done? As I said, the government has said, given everything we understand and know about pregnancy, given the state of affairs in our society around unintended pregnancy, unintended births, women's health, death and maternal health and maternal mortality and maternal morbidity, the public consequences when women have children they do not want, and we certainly should take on the public consequences of children that women want, even if we don't want them to have those children. Okay. If they want to have children, we should be there for them and their children. But if they don't want to have children, and they make a conscientious decision that it would be irresponsible for them to have children, and that in fact God doesn't want them bringing children into the world that they can't take care of, well then it seems to me we want to stand with them there too. So that's a decision the government made. We want to stand with them. We want to stand with this. We think this is a public health issue and a procreative freedom issue. And we're going to implement the public health, and we're going to implement that freedom by making contraceptives more easily available through employer insurance plans. Okay. And everybody has to do it. Every employer has to do it. Every employer has to do it. But certain employers have said that their religion prohibits them from providing those services. And let's be clear, they're actually not providing the service. Nobody is asking any employer, nobody is asking any hospital, nobody is asking any university health service to hand contraceptives to women. They're not even asking those institutions to write prescriptions for contraceptives. The mandate simply requires that the insurance policy they carry include contraceptive coverage. Okay. So then along comes, and I'm going to talk about this only in, because I have a limited time, only in relation to Catholic employers. Okay. So the government faced an enormous dilemma. An enormous dilemma. We believe in religious freedom, and we believe in honoring the consciences. In some cases, some people say only of individuals, and some people say of individuals and institutions. That's another complicated issue. But we want to honor the consciences of those people who have religious barriers, those institutions that have religious barriers. And in this case, clear, employers who have religious barriers. And along comes a number of organizations associated with one specific religion, one of the largest religions, Roman Catholicism. And the church itself, the parishes, the grammar schools, the high schools, the diocese, the national office, which are, strictly speaking, clearly the religion, want an exemption. But then a number of other institutions come along, hospitals that have an affiliation with Roman Catholicism, or that are doing their work as Roman Catholic as healthcare institutions or universities out of a faith-based commitment to education and health, also want to be classified as a religious employer. Now, the dilemma for me, and I hope we can have a chat about this, the dilemma for me is really, how does the government adjudicate claims that somebody gets up and says they are a religious institution? Because that is what is happening here. I think the point that people may also say, I religiously disagree with this, my religious belief says I can't do this, is really not the central question faced by government in this case. The central question faced by government was that a hospital came forward, or in this case, 600 hospitals came forward and said, we are religious institutions. We are the same as the parish. We are a church. And what we do in our hospital, we do because we are required to do it by our faith. And therefore, we want you, government, to classify us as a religious employer. 2 minutes, ooh, my goodness. And so the government shakes, scratches its head. This is a dilemma. This is not easy stuff, because a public good is in question. The public good for providing for the procreative freedom of our citizens. And a body of people is now asking us to say, we're religious employers. We want you to anoint us as if we are a church, to treat us just like a church. So that was one of the dilemmas. Are they or aren't they? And Obama made a very, I think, cautious decision in this sense. He said, okay, the churches are religious employers. They teach the religion, they employ the people of the faith, and they serve the people of the faith. Those institutions whose purpose is not the teaching of religion, who employ people of all faiths, and who treat people of all faiths are not a religion. That's one thing. I'm going to make one more point, and then I will honor this. I'll go over a little, but not much. Well, I'm going to take a little bit more, unless you're going to kick me off the stage. Okay. The second dilemma that exists now when government has to decide to give an exemption from public policy to an institution based on religion is, do we just take the word of the religion, of the entity, that this is required by their faith? 200 years ago, or when the Constitution was written, religion was a little less complicated. It wasn't without complications, but it was a little less complicated than it is now. So this is sort of like, maybe Scalia might have something to say about this, but I don't know. But now, religion is not so unified. Who does Obama listen to in terms of what Catholicism requires? Our elected officials are very smart about religious teaching. We have a lot of Catholic public officials, and they know that Catholics can use contraception. They know it's against the position of the church, but they know that Catholics can and are using contraception, going to communion, and being considered good Catholics. The church itself has said, you have a right to disagree with us on this topic. You're wrong, but you have a right. So how does Obama decide? How does the administration decide what is a genuine religious teaching? And so what is happening now, and this is a big issue, is the state actually forced, if we are now going to grant religious exemptions, is the state going to be forced to have official theologians on the payroll who can figure out what's a genuine religious teaching? And now I will conclude. Or is the state simply to take the word of the religious leaders or religious players in our society that this is required? And the challenge for that, for the state doing that, is that religious institutions and organizations have lied to the state. We cannot trust them to be honest about what is required. And so the questions I've tried to put for you are how we resolve those dilemmas.
Thank you very much. We will take questions from the audience. I was planning on asking a philosophical question, but I would much rather hear our two speakers engage one another. Matthew, would you like to take a couple of minutes to respond directly to Francis?
Yes, I wish I had more time.
Don't we really?
Yes.
Right.
Lawyers are not the only people who are in a win-or-lose game. Bureaucrats who impose policies, who take the abstract issue of what is right and actually impose it on people, they impose a win-or-lose game, and so the Nguyen family didn't have the option of discussing what is right. They were being forced to violate their beliefs. But I think that the dilemmas that you raised at the end of your talk are actually very important questions. Because it really is a dilemma to say, how's the government going to resolve the question of what is a church? How's the government going to resolve the question of now we're going to grant exemptions, who's going to get them? How's the government going to resolve the question of who's a religious employer that gets an exemption? The problem with the question is the premise that this is any of the government's business in the first place. Thank you. The First Amendment doesn't say the government gets to impose rules and then only allow churches off the hook and the government gets to decide who's a church or who's a religious employer. The First Amendment says free exercise of religion, not autonomy of churches in a very narrow sense, as long as they only serve themselves, is what gets freedom. The First Amendment says free exercise of religion is the standard, and the exception is the government mandate. Say if we have to save a child to get a blood transfusion because his parents disagree. So the problem is the premise that causes the need for state theologians. That's why we actually challenge in the case the fact that the Obama administration is attempting to pick and choose between religious beliefs and what's really a primary belief and what most of your employees. The problem is the assumption of the government's power to do that in the first place. The First Amendment and the Religious Freedom Statute that President Clinton signed preclude the government from making that attempt in the first place, or assuming that these religious people have lied to us before and we can't trust them and we're going to nail them and we're not going to give them any leverage. That's not the government's business in the first place.
Well, I guess I would ask you a question. Yeah, I guess I would ask you a question about that, because I think that, as I said, I think it's extremely complicated. But the question really is that it seems to me that the only way your point stands is if no other good is in question. Okay, we are dealing with and I'm not quite sure the extent to which, from your presentation, it seemed to me that you don't recognize, and I want to find out. I'm asking because I want to find out that you don't recognize contraception, the prevention of pregnancy, as in the decision-making process around when is it correct, morally correct, to bring children into the world, as an important good, or as even a freedom. And so therefore, you are only looking at the First Amendment, the religious freedom, and it trumps all other goods. So in that sense, it's like, yes, if there was nothing at stake here, fine, then you don't have to adjudicate, you don't have to figure out, you don't have to evaluate anything about a request, religious or otherwise, a request to be exempt from following a public policy that is democratically decided by elected officials in our country. That's the nature of our democracy. That's how it works. We elect people, they pass laws, we elect a president, an administration does certain things, and if the state does, we understand that. So those are public goods that we've acknowledged, and those public goods are coming into conflict with this. But as I said, it sounds to me like, the remarks that you make about forcing people to pay for somebody else's sex, which you yourself said, or that this is about the sexual agenda and the sexual liberty, seems to me that you denigrate pregnancy and procreative freedom. So fine, it's easy to say government stay out of it. So what do you think about that? What do you really think about that?
You can respond to that?
I would.
Want to get to,
yes. Okay.
No, I want an answer.
I would like to give an answer. And this was the second point I was going to hit, which is the definition of procreative freedom as you framed it. It does, and you framed it as procreative freedom, and you put it on the level, or at least as a comparison to religious freedom. But you're defining. I think that you're squeezing into the definition of procreative freedom again the right to coerce other people to help certain choices to be made. So this is similar to when you equate essentially the government ability to discourage pregnancy with the government ability to encourage it. The government ability to discourage pregnancy is a threat to freedom objectively as defined in a way that the government ability to encourage freedom is not. The government ability to discourage pregnancy is the discouraging of a choice, whereas the government ability to encourage pregnancy is the encouraging of a choice, but doesn't negatively impact any other. So in the sense that you say, well, I don't value procreative freedom, no, I don't define procreative freedom in the way that would say, well, I'm not really free unless other people are paying into a plan that covers what I want to do. No, I don't think that that's an accurate definition of freedom. It's certainly not what we mean by religious freedom. When I say religious freedom, I don't mean the government needs to pay for religion to happen. I just mean the government shouldn't be forcing me to violate my freedom. And so, thank you.
One of our questions is to Francis Kissling on just this topic. Why does the government think they have the right to encourage or discourage childbearing in the first place?
Well, first of all, as I said, I think that the question of government encouragement or discouragement of childbearing is very complex, and I tend to think that the government should neither encourage nor discourage. It's my own view. However, there's a long history in this arena throughout all of time in which governments do encourage and discourage pregnancy. Now, the question really is what kind of methods they use to do that. I would hope almost every person would think the methods used by the Chinese government are unethical, immoral, abhorrent, violations of human rights, etc. But does the Chinese government or the US government, in looking at the needs of all of the people and of the future, I think that there's a reason to be said, I think there's some merit to be said, it's a merit in the idea that encouragement and discouragement, or discouragement, that does not involve, and I take strong issue with you around your heavy emphasis on coercion here, because I don't think this actually fits the definition of coercion. But as long as those methods are not coercive, are not violent, etc., and are designed not through disincentives, but through incentives, that there are times when governments do need to make a decision to encourage or discourage. And as I said, I think what Matthew said is like the perfect example of a pronatalist perspective finds encouragement perfectly fine, but finds discouragement bad. I think that you have to look at both of them at the same level.
Like it or not, the government is involved in the provision of health care in a variety of ways: Medicare, Medicaid, pre-tax benefits for health insurance. I think the question is the way in which the government formulates those policies and the scope of those policies.
Why don't we get a couple questions on the table before we answer? Because we both like to talk.
For Matthew.
Your mic.
Okay, sorry.
There you go.
This is for Matthew. Matthew Bowman, almost half of women who use hormonal contraceptives do so for medical reasons other than birth control. How would an employer know what the purpose of a prescription is without an invasion of privacy?
Well, an employer wouldn't necessarily need to know. The insurance company, I'm not proposing that employers would need to know. I'm simply saying that assuming the purpose is known, and it's always known by the doctor and the patient, and then it's known by, they're submitting a claim. If you want insurance, you have to submit a claim to somebody. And so you have to tell somebody that you got something. That's not my system. That's the system that we have. It's usually not the employer. When the employer there are employers that self-insure, but even when they self-insure, usually a third-party administrator handles it. So what I'm not proposing is that employers know or have any involvement in a woman's own decision-making about what she's doing. What I'm proposing is that the employer can say on the plan, well, this is covered and that is covered. Well, how do you know that the thing that's not covered is the thing they're asking for? The same way you know that anything that's not covered is the thing that employees asking for. It's very rarely by the employer, if ever. I think it's really never by the employer.
I want to ask you a quick question. I promise you very quick. Matthew, do you think that an employer, how much freedom do you think an employer has in terms of religion religious belief, and you go further, moral belief. You don't even have to be religious, you have to have moral belief. But how much freedom do you think an employer has? Say, for example, the employer believes that sex outside of marriage is wrong, and that single people have no right to procreate. That's wrong. And therefore, he or she does not wish to have in their policy benefits related to pregnancy and childbearing. Because you shouldn't have done it in the first place. This is not an idle question. When I was a very young woman many, many years ago, insurance plans where you worked did not cover single people for pregnancy. You were not covered because you were not supposed to get pregnant, and it was based on. So what do you think? You think it's okay for employers then to say, look, you shouldn't get pregnant, you shouldn't be having sex, and now you're pregnant, my plan is not going to cover you because that encourages you to go out and do things you shouldn't do.
Well,
what do you think about that?
I'll concede that's it's a tough question, but I will make this point. Up until now, we've lived in this country without a federal mandate on that question. And I'm not aware of anyone coming forward with a religious perspective saying, I'm going to exclude pregnancy benefits because I don't think this single person should have them. I'm just not aware of it. I'd like to know if there is a case of that because I'd like to read into it. But the fact is that until August of this year, we have not had a federal mandate on this question. We've survived, and not only have we survived, we've survived without the parade of horribles of, oh, well, if you allow religious exemption in this sense, what will happen here, and what will happen with the Christian Scientists, and it hasn't happened. And we've gotten by. Nor have we had the
parade of horribles that you've talked about. Nor have we had the parade of horribles that you presented. You know, what if this happens, and what if they make you do this, and what if they make you inject the prisoner, and what
that's
if
because we protected religious freedom.
You know, but we haven't had that parade of horribles.
Because we protected religious freedom.
I don't think so.
I'd like to return to the question that was asked by a member of the audience. If an employee of the
Now you're off. Oh, sorry.
If an employee of Hercules Industries were to receive a prescription for hormonal contraceptives for estrogen for medical purposes, would that be covered? Should it be covered under the health plan that the Newmans believe that they should be able to provide? I mean, how would that be handled? I'm not sure I completely understood your response to the question.
As a factual issue, I'd actually have to go back and read the plan. But as a general issue, there are some employers who say, we're not going to cover contraception for contraception purposes, but we'll cover it for non-procreative related purposes. Belmont Abbey College, a Catholic college who filed the first lawsuit, does that. And that seems to be a workable distinction on the insurance side of things. I'm not aware of people claiming it's unworkable. It doesn't involve the employer making decisions on the question. I honestly don't remember what the Newland's plan does on that question, and I don't have it in front of me. But
some of the concern that this kind of case has raised has been with respect to privacy and intrusiveness on both sides, and I think that it needs to be addressed, particularly from the employer side, as to what sorts of healthcare services are provided and which are not provided.
The notion that the employer isn't going to have to pay for a certain thing in the plan in no way implicates that the employer is ever going to know what the employee is doing, because it's handled either by the insurance company or by a third-party administrator. And the federal privacy laws already govern that entirely.
We are running pretty close to 8:30. This is a fascinating discussion. I think, I suspect many of you have places that you need to be. So let me pose one last question from a member of the audience, which may help frame this whole conversation. Canada has universal health insurance. Great Britain has universal health insurance. How is this issue of religious freedom, particularly with respect to contraception, handled in those countries, which are similar in certain respects to the U.S.? This is a genuine information question, which I invite Matthew and Francis to tell us what they know.
Well, in both the UK and Canada, and in most of the European countries, contraception is part of universal insurance. And of course, that insurance comes from the government, not from individual employers. But the government, but it is included, and it is not an issue.
And I'll take Francis' word on that, and I suspect that abortion is also
And
included.
abortion is also included.
And
correct.
I would simply note also on the question of maternal health that the countries in the world that have the best maternal mortality rates are Chile and Ireland, which ban abortion. So the notion that necessarily one side of this agenda is in favor of maternal mortality is factually inaccurate.
Well, you have to deal with that. First, you have to deal with that quite frankly. First of all, in the case of Ireland, yes, abortion is illegal. However, Irish women in large numbers go to the UK regularly and have their abortions. So they get good, safe abortions in the UK. So the illegality of abortion is not the reason that Ireland has good statistics. In the case of Chile, I can't respond. I would have to look it up and do more of that.
Thank you very much.